Hello, everyone. Welcome back. We'll get started in just a moment. Okay. All right. Hello, everyone. Welcome to this session of Alt Legal Connect. The session is Spring into Office Action, dealing with and overcoming OA refusals. Also, not my pun, just so you know, that credit I believe goes to Ruky. This session is sponsored by 2 Weeks to Trademarks, so thank you very much for that. I am Brie Vantil. I am the Director of Education at Alt Legal and the Master of Ceremonies for Alt Legal Connect. I'm here to make sure that you have a wonderful time at Alt Legal Connect. So if you have any feedback for me, please let me know. If you have any feedback, another thing that we would love to have you do is to use the feedback tab of Brella. It's right next to the chat. So please use that to provide us with some feedback. We absolutely appreciate it. We care about making this conference great for you. All right, do need to remind you that we do have a code of conduct that says don't be a jerk. I don't anticipate it'll be a problem, but I'm going to remind you anyway. All right, we are offering CLE credit for this session through the state of California. Please note that CLE credit is available for sessions that are attended live only. So if you're watching this via recording, you're going to learn a ton, but you're not going to be able to get CLE credit for this. I do need you present the entire time, and please note that this is a 90-minute session. That is 90. So get ready. It's going to be amazing. Please do write down the code when I present it. Don't count on yourself to remember it. They're complicated. There will be no spaces in the code. When we send out the survey at the end of the session, make sure to put that code in there, and then you should get a certificate of attendance. All right. Alt Legal is still a legal technology company, not a law firm, so we're not presenting you with any legal advice. And while our 3 presenters are lovely and knowledgeable attorneys, they don't necessarily represent the views of Alt Legal. All right. Definitely do chat amongst yourselves using the chat, because what else would you do with it? But if you have any questions for the panel, go ahead and put them in the chat as well. But go ahead and start that with the word question, just so that we know and we can get those questions over to them. I'm really excited about this panel. Our 3 panelists are Erik Pelton, Kelu Sullivan, and Ruky Tijani. So Erik Pelton was the only person I know who has a circle R after his name on LinkedIn. Just random fact. He's the founder of Erik M. Pelton Associates. He's a former USPTO trademark examiner and the author of Building a Bold Brand. When he isn't representing clients or publishing books, you can probably find him in a classroom where he teaches trademark law at Howard. Kelu Sullivan is a trademark attorney and a partner at Kelly IP. She manages thousands of filings globally. She used to do substantially more litigation, and she uses that experience to inform her trademark prosecution practice. Kelu also teaches a course on IP advocacy at Iowa College of Law. Ruky is a trademark attorney and the founder of Firm for the Culture, where she focuses her practice on representing social entrepreneurs. In addition to managing her legal practice and representing her clients, Ruky is also the founder of First Generation Purpose Project, an organization that seeks to coach first-generation professionals and entrepreneurs through their lives and careers. Here is the panel.
Thank you so much for the introductions, and thank you to Bree and to Nehal and to everybody at Alt Legal for putting together this amazing conference and for inviting me to moderate this wonderful panel with my esteemed colleagues, Ruky and Kelu. We are so thrilled to be talking to you today about office actions and to really talk about office action responses on 3 key substantive issues. You will see failure to function, likelihood of confusion, and descriptiveness. And of course, these are uh, always present in our work filing for clients with the US Patent and Trademark Office. And we are going to get to a lot of substance today on these topics and save time for your questions at the end. So without further ado, I want to kick it off to Ruky to tell us all about failure to function refusals in depth.
Absolutely. First of all, Erik and Kelu, it is an honor to be here. Alt Legal, you people are my people. So I'm super, super excited to be here. So I want to jump into the failure to function refusals, which has taken, us as trademark attorneys kind of, it's taken the whole trademark world by storm, particularly the commonplace and informational failure to function refusals. So that's what I'm going to jump right into in the context of my discussion today. So Bree has already talked about us, so I'm going to zoom right into the meat of our presentation. So as many of you who know me know, I am a millennial. I graduated from UC Berkeley School of Law not too long ago, and after working in a litigation firm in the Silicon Valley for a few years, I decided to start Firm for the Culture, which really mixes intellectual property, law, and education with pop culture and diversity. So I'd like to take a nuanced approach to unpacking and understanding failure to function refusals, and we're going to look at it against the backdrop of pop culture. And I like to say that this is a tale of two trademarks instead of a tale of two cities. And we're going to review the failure to function refusal in the context of these two trademark applications, one by LeBron James and one by Meg Thee Stallion, both of which received much fanfare and attention, at least in the beginning stages of the application. And we're going to take a deeper dive into each application to glean what a failure to function refusal is, successful arguments in the failure to function realm, and tips to prevent and or overcome failure to function refusals, as well as lessons that we can take away from the applications to become better advocates for our clients. So before I jump in, I did want to start off with a caveat about the nature of commonplace failure to function refusals in the time that we've seen the uptick in the issuance of office actions, particularly mid-2019 to current. That's really, according to one New York University article, that's really where the uptick of failure to function commonplace refusals have really kind of taken us by storm. So there are a ton of scholars who have not only critiqued the inconsistency in which such office actions are issued, but they've also critiqued the inconsistency in the analysis for such issued office actions. While preparing for this presentation, Kelu, Erik, and I had the chance to really talk through a lot of the substantive refusals that we're going to discuss in this presentation today. And Erik sent me this amazing article by a New York University Law Review article by a young scholar named Lucas Daniel Cuatrecasas, in which he notes, amongst other things, that as a TTAB uses it, the failure to function doctrine is incoherent and it lacks clarity. On a more granular level, the doctrine rests on an inconsistent multi-factor test whose factors the TTAB adds, subtracts, modifies, and reconceptualizes seemingly at whim. And because of that, the USPTO has given little meaningful criteria by which to decide what actually merits registration and what constitutes a true failure to function. And because of that inconsistency, a lot of the costs are bore on to us as, business owners. Because if we don't know if a mark is going to fail to function as a trademark, notwithstanding the fact that there may be actually similar or identical marks already on the USPTO principal register, then it can mean that it's kind of like a shot in the dark or gamble. So I'm saying that to say, while this presentation, I hope, demonstrates the overarching arguments that have been used to successfully overcome failure to function refusals, there's really no clear criteria to truly assess whether the mark fails to function as a trademark, at least according to the pattern that we've been seeing since the uptick in such refusals in 2019. But in any event, let's jump right in. So first, let's go into the trademark tales. And feel free, Erik or Kelu, to cut me off or tell me that time is, because I can geek out a lot. So let's talk about LeBron James and Taco Tuesday. So in August 2019, LeBron James, an American professional basketball player for the LA Lakers, applied to federally register the phrase Taco Tuesday after videos of taco nights with his family became widely popular on social media and beyond. And he sought to register the phrase for, among other things, podcasting services, advertising and marketing services. But in a detailed 78-page office action, LeBron James was denied federal registration for the term Taco Tuesday. So let's jump a little bit into the reasoning that the USPTO gave. So the USPTO said that the mark failed to function as a trademark because it is so quote unquote commonplace that it fails to indicate the source of the applicant's goods and distinguish them for others. In other words, the USPTO noted that because Taco Tuesday as a term is used on a myriad of different businesses by different individuals, different entities to express enthusiasm for tacos by promoting and celebrating it on a dedicated weekday, LeBron James could not use the phrase Taco Tuesday. So essentially what they were saying is because everyone is using it, no one person should be able to own it. And in fact, they cited to at least 11 different sources. And I don't know if it's big enough, but they cited to at least 11 different sources stemming from news and social media to show that consumers were accustomed to constantly seeing the term Taco Tuesday associated with a bunch of different sources that were not LeBron James. So in conclusion, because consumers were so accustomed to seeing it by many different sources, the mark Taco Tuesday could not do its job as a trademark, which is pointing customers and consumers to one source. So seeing no way to overcome that refusal, LeBron James abandoned the application in March 2020. But similarly, around the same time, Meg Thee Stallion was also denied federal registration in October 2019 for the term Hot Girl Summer, in association with, amongst other things, musical sound recordings, t-shirts, posters, clipboards, and tour books. Now, like LeBron, Meg Thee Stallion is a professional at the top of her game, but a musical entertainment for providing fun and carefree and popular viral videos that keep tweens and TikTokers alike hanging on her every word. And one of the songs that went viral was Hot Girl Summer in 2019. It was a song featuring Ty Dolla $ign and Nicki Minaj, and it became a real summer sensation. And like LeBron's application for Taco Tuesday, the USPTO denial noted that Hot Girl Summer was common and a widely used phrase from several different sources. And thus the term Hot Girl Summer did not function as a trademark to indicate the source of the applicant's goods and to identify and distinguish that set of goods from others. So again, it was the whole rule that because everyone was using it, no one person should be able to own the term. But the difference between Meg Thee Stallion's case and LeBron James' case is that Meg Thee Stallion actually became successful. At least as of the time I started researching the issue, Hot Girl Summer was approved for publication. And as of yesterday, just yesterday, the USPTO issued a notice of allowance, meaning that all Meg Thee Stallion has to do now is actually show that she's utilizing the term Hot Girl Summer in association with the musical recordings, the t-shirt, the posters, and the like, in order to receive a fancy schmancy registration on the principal register. So what made the difference? What made the difference for Meg, and how can we actually overcome these pesky refusals? So before I jump into that, let's get down to the basics. So what is an actual failure to function refusal? So at its core, a failure to function refusal is a shorthand note noting that a phrase, slogan, or color, or symbol, or even sound fails to function as a trademark. But let's get even deeper, because I think that's deceptively simple. In order to understand what a word, phrase, when a word, phrase, or color fails to function as a trademark, we must first understand what a trademark is. So I'm going back to the basics, right? So according to the Lanham Act, According to the Lanham Act of 1946, a trademark is a word, a name, a symbol, or a device that's used to identify and distinguish one's goods from those manufactured or sold by others to indicate the source of the goods. So in other words, a trademark is a word, a symbol, a phrase, a logo to differentiate your business from others. And as a mark of your trade, a trademark's primary job is to point the consumer back to the source of goods and the services rendered under the mark. So the Starbucks Mermaid, for instance, when you put it on a cup of coffee, points consumers to that Seattle-based coffee company, while Golden Arches, when you put it on that same cup of coffee, points consumers to McDonald's. And it is the different marks that distinguish the same product, in this case coffee, from each other in the minds of consumers. So against this backdrop, a word, name, and I know I keep on reiterating it, but I want to really drive it home. Against this backdrop, a word, a name, a symbol, or a device fails to function as a trademark when it does not, in the minds of consumers, indicate the source of goods and services. So when a trademark doesn't do its job in terms of acting as a source identifier, it consequently fails in its primary job to function as a trademark and will be refused registration. And indeed, in many of these cases where the USPTO issues the failure to function refusals, they say, in very fancy words, the Trademark Act is not an act to register mere words, but rather to register trademarks. So before there can be registration, there must be a trademark. And unless words have been so used, they cannot qualify. And I think it's interesting because it's as if the USPTO is kind of sitting on this chair and saying, we are not in control of determining whether some words or phrases or symbols and the like are actually trademarks. That job is for the consumer. And we are simply there to identify, give imprimatur, or recognize that a phrase is a trademark or a phrase is not a trademark. So the failure to function refusal against this backdrop has been issued in many different contexts, including trade dress or 3D trademark refusals. You'll actually see that a lot of the reasoning for failure to function refusals really do come from that scope, the 3D or trade dress refusals, or when an applicant's mark is simply the name of a performing artist. One recent rejection that I saw was for the 69 Boys. Because the name was merely an artist name, the USPTO said that the mark failed to function as a trademark. Or when the applicant's mark is simply the title of a single work, such as a CD or book, or when the applicant's mark is commonplace, informational, or a widely held message. And while these in other contexts all seem to be different, they're merely different ways of expressing the same exact message, that the applied for matter fails to serve as a source indicator in the minds of consumers. And because of this, the applied for matter fails to function as a trademark. But for purposes of this discussion and to keep time, we're going to review the commonplace failure to function refusals. So in my study and in my team study of failure to function refusals, particularly the ones that have successfully, where applicants have successfully overcome such refusals, we saw that there were four main successful arguments that we were seeing over and over and over again. And this presentation is really going to dig deep into them with examples. So the first argument is this is actually not that commonplace argument. And it's the argument that the mark is not actually commonplace in the particular industry of the applicant's goods and services. The second argument is that the mark is distinctly different from the phrase the USPTO deems commonplace. The third argument is that several similar marks were registered, so the applicant's mark should be registered as well. But even then, I would say with the caveat, this argument has not always been consistently accepted. See Mama Bear, for instance, for clothing, to see how that argument was essentially refused. And then the fourth argument is that all marks point back to the applicant, contrary evidence notwithstanding. So again, these are not all the arguments that can be made, but these have been the arguments that we've seen over and over again in our research that I wanted to bring to your attention. So let's jump into each of them. Let's jump into the first one, noting that the mark is not actually that commonplace. And I see your question, so hopefully by the end we'll go over it because Erik is the moderator, so he'll let me know. So We're going to look at Lands of Liberty, and the registration number is on the screen. And in 2017, the America Remembers Corporation filed an application to register the phrase Lands of Liberty in association with firearms in Class 13. And the USPTO, citing several publicly available sources like Wiktionary, Tribe Live, WordNick, denied the application, noting the expression Lands of Liberty is commonly used to refer to the United States of America and conveys a sentiment that the United States represents the values of individual freedom and liberty. And to counter this, the applicant noted that even assuming that the phrase Lands of Liberty was commonplace generally, registration was still warranted because the phrase Lands of Liberty is not commonplace when used in particular with firearms in Class 13. So here are some portions of the argument. The applicant said the phrase Lands of Liberty is not a commonplace descriptor in connection with firearms, and the office action does not support that it is a frequently used descriptor in that term. And they actually said the examining attorney failed to even point out one instance in which the mark was used in association with the sale of firearms or related goods. So essentially what they did was they narrowed down the relevant public in terms of assessing what the consumer perception as to this otherwise generally commonplace term is. And they narrowed down the relevant public to argue that the people who really matter, essentially the purchasers of firearms, would not actually see this mark as commonplace. And because purchasers of firearms, particularly in Class 13 and related classes, wouldn't actually see this mark as commonplace, the mark could still serve as a source identifier. And the USPTO actually accepted that argument, so much so that they registered the mark in July 2018. So the next argument is that the mark is distinctly different from the commonplace phrase. And for this one, I want to use the application for Be the Change. Now, I know that there's a delay between the questions and the comments and it getting to us, but I want you to start thinking, even if the answer doesn't come to us, I want you to start thinking, what does this phrase remind you of? Be the change. What does this phrase remind you of? It's probably Mahatma Gandhi's famous, quote, "Be the change you wish to see in the world." So the applicant applied to register the mark "Be the Change" in association with educational services in the field of mental and physical health, wellness, nutrition, physical fitness, and time management. And citing several different websites, the USPTO denied the application, noting that the expression is commonly used to refer to the quote from Mahatma Gandhi, "Be the change you wish to see in the world," and conveys that one can initiate personal change so we can rise to the challenge and become a bigger and better person as a result. So according to the USPTO, because consumers were accustomed to seeing that term or expression commonly used in everyday speech by a bunch of different sources, they would not perceive the mark "Be the Change" as identifying the source of the applicant, but rather just simply conveying an informational message. So anytime you saw the message on a shirt or the message on, marketing materials, it was simply telling you, you need to be the change you want to see in the world. You need to be this bigger and better person, rather than pointing to the source of the goods, in this case, the applicant's physical fitness and coaching services. But the applicant shot back, and the applicant said, no, that's actually not what we're doing. Be the change you wish to see in the world is not actually the phrase or the term that we're applying for. It's simply "Be the Change," which is the applicant's mark. Essentially, the applicant said to the examining attorney, hey, you don't have any evidence to assume that a consumer, whenever they see the term "Be the Change," will almost always add 8 more words "you wish to see in the world" when looking at the applicant's educational, coaching, goods, and services. So in the end, the applicant argued that an attenuated attribution of the applicant's mark to a pre-existing quote cannot be enough to prove that the mark fails to function as a service mark. So what the applicant essentially says is just because it may remind you of a commonplace or informational message doesn't mean that the actual term at issue in the application is the commonplace or informational message. And the USPTO looked like they accepted that, because on January 7, 2020, the applicant was allowed registration. So that's one of the, so again, those are two of the four arguments. The first one is this mark is actually not as commonplace when we narrow down the relevant consumer. And then the second one is this mark is actually not matching the mark that you deem as commonplace or informational. So it's really getting granular, really getting into the details of the mark at issue. Now, the third argument that we've seen over and over again is the I should be added as well. I like to call it the I should be added as well to the principal register. And we've actually seen a lot of this in the likelihood of confusion space when we argue crowded fields, for instance. So this argument essentially says because several similar marks were registered, applicants' marks should be registered as well. And I want to point us to the application for Dare to Be Different. So in 2019, Dare to Be Different LLC applied to register the mark Dare to Be Different in association with cookbooks and frozen vegetables. And the USPTO citing a host of different books. Let me just make sure we're on the same. Yeah. Citing a host of different books and cooking blogs, concluded refusal was warranted because the wording Dare to Be Different was a term or expression that was commonly used to express support for people who wanted to change or depart from the ordinary. And indeed, the USPTO noted that the evidence cited showed more widespread use of the wording in book titles, blog entries, and news articles. And I wanted to point that out because these are the types of specimen or evidence that the USPTO is citing over and over and over again. They're citing books, they're citing t-shirts, they're looking at Pinterest, they're looking at Etsy, they're looking at Amazon to actually ask how commonplace is this term, whether or not the term is kind of used in the trademark sense. So if you actually look at the Dare to Be Different specimen, I just want to kind of point that out. A lot of the specimen are shirts and books, which in many other contexts wouldn't qualify for trademark registration, right? Because the t-shirt, to the extent that they have Dare to Be Different on the shirt, would likely be ornamental, right? Or the books, to the extent that they have Dare to Be Different as a book title, wouldn't likely function as a trademark, right? But in any event, because these terms are seen on many different goods and services in the general marketplace, the USPTO said that Dare to Be Different was a commonplace or informational term. But in response, the applicant went back to the principal register, noting that the USPTO issued, the following registrations on the principal register for essentially the same phrase, Dare to Be Different, in numerous classes of goods and services. Dare to Be Different for stationery items, Dare to Be Different for hair color, Dare to Be different for hotel and private residences, Be Different for conducting workshops and seminars in Class 41. And the applicant cited to these arguments to say that there is proof that the USPTO has a precedent that the mark functions as an indicator of source and is eligible to be registered. And they essentially called the USPTO out, and they said the USPTO needs to be consistent in its determinations, and it would not be logical or consistent to refuse registration of this mark, in this case on a failure to function refusal basis, because of the foregoing registrations, which provide persuasive evidence that the applied for mark, in this case, is distinctive and functions as a trademark for the goods. Now, while I noted that this argument has not always been accepted, it was accepted in this case as registration was given to, thank you, Erik, registration was given in October 27, 2020. Now, I'm going to go really quickly for the purposes of time for the last one. The last one was, the last argument that we saw over and over again was that all marks point to the applicant, contrary evidence notwithstanding. And I'll say that I saw this argument successful in the case of the applicant serving as the celebrity, actually, and not in a lot of other contexts. So I'll give you a little bit of an example. And this is with regard to Baby Got Back. So I'm sure you know where Baby Got Back comes from. Anthony Ray, also known as Sir Mix-a-Lot, and the writer of the widely popular 1992 song Baby Got Back. And he applied in 2016, he applied to register Baby Got Back in association with t-shirts and sweatshirts and headgear and caps. And the USPTO denied registration, saying that Baby Got Back was commonly used to refer to a woman that had a shapely, round butt. And as with other failure to function refusals, the USPTO said that because customers were accustomed to seeing this expression commonly used in everyday speech by many different sources, they could not perceive it as pointing back to Sir Lancelot or Sir Mix-a-Lot. And Sir Mix-a-Lot came back and noted that while it was true that there were several sources that carried the phrase Baby Got Back, many, if not all of them, pointed back to the applicant and not to a different source or entity or business. So to the extent that consumers were accustomed to seeing and hearing the phrase Baby Got Back, it was oftentimes, if not almost always, associated with the applicant, Sir Mix-a-Lot. And he's the only person that has a Wikipedia entry for Baby Got Back. And it's so strongly associated with the applicant that when consumers see it, they immediately think of the 1992 cult classic. And the mark was registered on April 4th, 2020. So I'm just going to kind of go through really quickly, like what happened in terms of Hot Girl Summer and the arguments that she used. So she used the Baby Got Back argument in essentially saying that any reference to Hot Girl Summer pointed unequivocally back to her. And she said she's known as Meg the Stallion, Hot Girl Meg, and the head of Hot Girl Summer. In fact, she pointed to the dictionary definition of Hot Girl Summer and noted how a small note in the dictionary definition of Hot Girl Summer specifically referenced Meg the Stallion as the originator, if not the source, of Hot Girl Summer. And she said that the mark didn't exist prior to her, given the timeline and the origin and the growth of Hot Girl Summer with the applicant, that's a source identifier. The mark was largely non-existent before she came on the scene and started using Hot Girl Summer. But what about the fact that there were Hot Girl Summer shirts and Hot Girl Summer, phone covers and Hot Girl Summer books everywhere? She said that the common use in the marketplace was nefarious and illegal. And in any event, anytime someone saw Hot Girl Summer, it unequivocally pointed back to her. And essentially, these very creative arguments over the course of 2 to 3 years, I wouldn't say convinced the USPTO because she got to TTAB and the examining attorney had to respond, but the examining attorney declined to respond. So as a result, the Trademark Trial and Appeal Board said, okay, in light of the examining attorney's absence, we're going to let the case proceed to registration. And she was issued later on a notice of approval. So I believe a copy of the slides will be given, so feel free to look at it. But tips to avoid office action refusals. So the first one is count the examining attorney's evidence. Look at the examining attorney's evidence and actually count the number of exhibits that the examining attorney presents. It may be the case that they may have cited 3 or 4 sightings of the mark in the general marketplace. That's likely not enough for a commonplace refusal. The second one is narrow your niche. Oh yeah, narrow your niche in terms of really arguing who the consumer is, and also research trending hashtags to see how ubiquitous this mark is, because the more ubiquitous it is, the more likely it is that the USPTO is going to refuse your mark on failure to function grounds. Grab similar registrations that support your argument. So gather registrations to see if there are similar arguments that can be made, or arguments that can be made citing to the similar arguments to show that By other examining attorneys, this mark was seen as a functioning trademark. So again, a copy of this slide will be given. So I'm going to kind of hold off, and I know there's so much more to say, but I'm going to hold off and await questions and let my colleagues present their portions.
We have lots of great questions in the chat. We're going to try to save time at the end to get to some of those questions. We want to make sure we get to all the substance first. And for these slides that you're seeing right now, make sure you download and look at those in detail, because there's even more great tips that Ruky has put together there regarding failure to function. The one that I think will come up repeatedly throughout our presentations today is the evidence, and making sure we review the evidence that the examiner has attached and making sure that it actually says what the examiner says it does, or sometimes, as in this case, like you said, the evidence may actually point to the applicant itself, and the examiner may not realize that.
Yep.
I wanted to ask you one question before we move on to likelihood of confusion. You mentioned sort of the change in mid-2019 when we saw many more of these refusals.
Yeah.
So two-part question is there something in 2019 that we can point to as the cause of the change? And the second part would be, when someone's reviewing Taco Tuesday or other marks that may be on the register from prior to 2019, how much should they give that timeline consideration?
That is such a good question, Erik. I am not too sure if anything in particular happened in 2019 to make the USPTO say, hey, we're now going to issue a bunch of failure to function refusals. But as to the question, as to the timeliness or considering each application in context, one of the rules that the USPTO is now kind of like tacking itself onto is the fact that trademarks are not static. They're constantly saying trademarks are not static. So just because a registration was issued, 2 or 3 years ago doesn't necessarily mean a registration can be issued now. So I would say one of the things that you should likely look at is when the registration was issued. Was it issued 2 years ago? Was it issued 3 years ago? And I would say probably line that up with a tool that I like to use called Google Trends to see how popular that particular phrase was at the time the registration was issued. Because one of the things that I'm seeing over and over again in the failure to function kind of context is the USPTO is also looking to the popularity of a particular term or phrase to determine if, it's being used more than often, such that the registration should not be issued in a particular case. But I do want to circle back at that 2019 kind of trends. I'm going to look that up.
Okay.
And get back to you on that. But hopefully that answers your question.
Great. And now Kelu is going to unpack everybody's probably most common substantive issue that they get to deal with the Patent and Trademark Office and 2D refusals.
Yeah, thank you, Ruky. Thank you, Erik. So unlike Ruky, I am not a millennial, so this is going to be a more, traditional presentation on the likelihood of confusion refusal. And I think it is one of those substantive refusals, when you first see it, your heart drops a little bit because, you're, especially if you had done a search, you're going, oh my goodness, how am I going to be able to overcome this, or how do I explain this to the client? But it's also one of the things that's not so scary if we go through some tricks and tips that I will discuss in this presentation. So first, let's talk about what is a likelihood of confusion refusal. Section 2D of the Trademark Act bars registration of apply for marks that so resemble a mark registered in the Patent and Trademark Office or a mark or trade name previously used in the United States by another as to be likely when used on or in connection with the goods of the applicant to cause confusion or to cause mistake or to deceive. And so in the context of an application before the U.S. Trademark Office, what you are looking at is the Trademark Office examines your application, they do a search of the USPTO records, and they identify any prior registrations or prior pending applications, and I'll talk about that distinction in a little bit, that bars or may bar your application based on the mark and the goods and services in the application. So it's a little bit different than an infringement analysis, and I will go into a little bit more detail. So here is many of you probably have seen example Section 2D refusal. It's an office action. It says Section 2D refusal, likelihood of confusion, and they cite in this particular case 5 different registrations, and they usually provide some analysis as to the similarity of the goods and services as well as the marks. They may attach some evidence to support their argument, and depending on what the how some of the marks are or how some of the goods and services are, like Erik said, let's take a look at the evidence. That's the first thing you do. Look up those registrations that's been cited and figure out what your next steps are. All right, so when you first get the office action, my recommendation is I have a little checklist that I go through to see what I can do to overcome this refusal. So first thing I do is I pull up all the cited registrations and I check the status of those registrations and see, are any of them due for renewal? Have any of them fallen into the grace period? Have any of them not been renewed or maintained under Section 8 and 15 deadlines, so that you can see if maybe that's no longer really a reference because it's going to actually be canceled within the next 6 months before your office action response deadline. And a tip on that is, if a cited registration is in the grace period, you can ask the examiner to suspend the prosecution of your application pending the outcome of whether or not that registration will be renewed. But that's only if it's in the grace period when you respond to that office action. So that gives you a chance to see what happens with that cited registration and decide whether or not you want to make arguments, or if you want to limit your goods and services. If you don't have to, maybe you don't, and keep your application broad. And then the second thing I do is to see, okay, the registration, it's in good standing, it's not going to be due for renewal for a couple more years. Is the registrant still using the mark, right? Because sometimes companies close, they get bought out. And so even though the registration is still active and alive, the registrant may have abandoned the mark. Now, in the US, abandonment requires cessation of use plus intent not to resume use. Sometimes the intent part is very difficult to determine, but sometimes you get lucky and you get a news press that says, XYZ company got bought by ABC company and XYZ company is no longer in operation. So that might be a good tool to use, and you can decide whether you want to file a petition to cancel based on abandonment, or once the TMA is in act, maybe you can qualify for one of the new non-use proceedings. All right, so then we look at the prosecution history of the registration, and we look to see the specimen that was submitted. It doesn't really work for applications that were registered under Section 44E or 66A registrations, because they don't need to submit a specimen until the Section 8 period between the 5th and 6th year of registration. But for others that are filed based on use, look to see, are the specimens suspicious, right? Because in the past few years, we have seen a rise in registrations that were issued based on faulty or inaccurate or digitally altered specimens. So take a look at those, because then those registrations may be vulnerable for cancellation as well, because they were registered essentially based on fraudulent specimens. And then the other thing to look at is, does your client actually have priority? Because sometimes clients may have used the mark for many years but never registered it, or maybe they have a prior registration that maybe was not as broad in scope, and this is sort of a gap filling application that you filed for your client. So maybe there is priority that you can use then to create a strategy to overcome the refusal or enforce against the cited registration. And then check, so in addition to the specimen, I would check the prosecution history to see if they made any arguments that might help you. There were a few times where I have found that the cited registrant made these arguments to overcome a prior registration. It refuses that, oh, you know, our clients' products are in a completely different trade channel than this other registration, and you happen to be in the exact same trade channel. Sometimes you can use that to bolster your argument. It's not conclusive, but you can say, look, they already admitted in the prosecution history that there is no likelihood of confusion between these two products. So sometimes it helps. It's not a guarantee, but it might help you craft arguments to overcome that citation. And then finally, whether or not you can amend the description of goods and services to overcome the refusal. So a couple things to think about is, are there channels of trade identified in the prior in the cited registrations that you can distinguish? We'll talk about a few examples there. And then, you know, or is it really, you know, for example, there's clothing, right? So it could be clothing for you know, soccer players, or clothing for swimming, or something that's a little bit niche that you can use to distinguish your client's mark and products from the cited registration. So those are all sort of things I run through you know, before I craft a strategy and discuss with the client about how to overcome the refusal. All right, so then, you know, let's get to sort of the meat of, you know, how does the PTO consider likelihood of confusion? So they look at, you know, 13 factors. They're called the DuPont factors before the PTO. And, but here are the most common factors that's considered before the PTO, although all 13 have made an appearance in TTAB cases and been sort of the determining factor in making decisions. So first, similarity or dissimilarity of the marks, similarity or dissimilarity of the nature of the goods and services, similarity or dissimilarity of trade channels, conditions of purchase, and fame of prior mark. So on, you know, something that Ruky had mentioned earlier, which was, you know, when there's a crowded field, right, there's a lot, you can say, me too, let me get in there, right, let me add me too. Well, so the fame of the prior mark comes into play. So it could be that when you do a search and you find that there are, in fact, 30 different registrations of same or similar mark, you know, same root, right, of the word for a bunch of different goods and services, but sort of in a related field, like in the field of finance or in the field of software, so that if you make a sufficient distinction between your client's product or mark and their, you know, the cited registrations, products and goods or marks, then you can say, look, there's no confusion. Consumers have been conditioned to distinguish these different marks in the crowded field, and so we should be allowed to register our mark too. So that's something to consider. You know, these are the factors you would run through, compare side by side between the cited registration and your client's mark and application. All right, so then we have some substantive arguments that we can discuss. So the first is the cited mark's inherently weak or relatively weak. You know, so if it's inherently weak, it is a mark that is just on the right side of suggestive, or it was a descriptive mark that has become shown acquired distinctiveness under Section 2F, or if it's a mark like Taco Tuesday that maybe once was sort of unique but is no longer unique, so that you can sort of slide in. But the danger of that is you don't want to make it so weak that your client's mark is no longer considered a mark. So you kind of have to walk a little bit of a fine line there and on the how strong a mark is. And then you look at third-party registrations like we talked about to see what else is out there. So for the relatively weak argument, you have to provide the registrations and also attach to your response copies from the PTO records and it can only be registrations. Sometimes I'll include allowed applications but it can't just be pending applications, because that doesn't mean anything has not been examined. They don't necessarily coexist on the register. So, and the other thing to note is if the prior registration is on the supplemental register, it's not the same thing as the cited registration is on the principal register. So check all of those things before you formulate your response. All right, so then the second one is, are the marks dissimilar in appearance, connotation, or commercial impression? And it can be one of these things. It does not have to be all of those things. And some examples we'll look at later, some of the marks look visually, you look at it and go, wow, that's the same. But think about the connotation, the meaning of that mark as applied to the goods and services in the registration or in your client's application. And when it's in that context, does it make a difference? Does it sound, have a different meaning to the client? Because the same word or same phrase can mean something in one context, but mean something completely different in a different context. And it is all contextual for the application. And then finally, look at the relatedness of the parties' goods and services. Are they different products? Are they sold in, to different types of purchasers, right? Are they, if, for example, if prior registration says it is supplements for people who are 50 or older, maybe your sports drink or something does not have an age limit, or your supplement is for someone who's younger, and the connotation maybe is a little different. And then you look at sophistication of consumers or the purchasers. Is this a really expensive product that the clients or customers would take a long time to decide? It's a multi-million-dollar piece of equipment that you purchase for a scientific laboratory, or is it a pack of gum that you buy at the checkout at the store, right? So how much care does a purchaser give in considering whether or not the marks or will be likely to be mistaken as to similar of the products and the source of origin. So that's something to think about, and to keep in mind that when you're looking at office action responses, you have to look at the registration on its face and what it says, and what you can naturally infer from the language of the registration in the goods and services is you can't say, well, I went out to this, the restaurant's website and look, like their product is only sold in their own stores and it costs, hundreds of dollars, versus my client's goods, which is identical, but is sold at a convenience store for $3, right? So it has to be something that's in the registration. That might make a difference when you're in district court litigation discussing, arguing over likelihood of confusion. But from the PTO's perspective, unless there is a restriction that's in the registration or a restriction that can be read naturally into the registration, that's kind of obvious that the ordinary trade channel or the ordinary customer would be X, Y, Z, they can't import that evidence in to make that determination.
That's a great point, and it actually answered one of the questions we've got. A very good question. I just wanted to go back to the prior point you made about sophisticated purchasers. Mm-hmm. What type of evidence or arguments have you found persuasive regarding sophisticated purchasers? Because I think we all intuitively know that some things are more expensive or more care goes into them, but how do we, as practitioners in these situations, demonstrate that?
Yeah, and sometimes that can be difficult if it's not obvious from the face of the registration that, it is sold in, special boutiques or something like that. But I think you can use your intuition a little bit. Your client's business, and you can do some research on, for your own information on the registrant's business. So, for example, vehicles. A lot of times, there is this assumption that when people make purchase of vehicles, they take a long time to consider how to make that decision. Or if it's, for example, like investment services, but it's like high level investment services, sometimes that can be used to indicate sophistication of purchasers. I think another example I've seen is software for hospital records. Sometimes that can be seen as, well, hospital records are, highly sensitive, and the people who are making those decisions would, take time and will be sophisticated in determining these different types of services. So I think you look for any clues you can get that you can say, look, their registration says X, and X is typically purchased by sophisticated consumers. It's not always obvious. I think, for example, clothing would be difficult to say, or like food items, but if it's, but sometimes, supplements or expensive medication, sometimes that can, you can sort of infer who will be purchasing this product and whether or not they're sophisticated. But it's sort of a case by case, and it's even in the same field, I don't think you can make the same assumption for the type of purchaser. And then, lastly, I think we touched on this, like trade channels in terms of what is an ordinary channel of trade for the product, right? For, the internet is no longer, if there ever says, well, everything's on the internet, well, that's no longer a valid, like, similar trade channel. But sometimes registrations will actually specify the trade channels that they're sold in, usually to overcome a prior refusal. Sometimes they don't, but it's fairly obvious based on the products, right? So software for use in military drones, right? So you can sort of guess what that trade channel is versus just, casual consumer drones, for example. All right, so we are going to talk about some examples, as I sort of hinted earlier. So this is a 2013 TTAB non-presidential case. It was an ex parte appeal. The applicant filed for the mark The Works for restaurants and for clothing, but we're not going to talk about restaurants because that was not successful. But for clothing here, so it said clothing, namely t-shirts, tank tops, etc., related to restaurant services and food products. So that part was added in the prosecution of the application when they received refusal based on Works clothing, namely t-shirts, related to motorsports racing jerseys, and motorcycle racing pants. So this was a clever thing to have done. It didn't convince the examiner, so they did have to go to the TTAB, but the TTAB agreed with the applicant in this case, and they said that clothing related to a restaurant is not connected to clothing related to motorsports. And the ordinary trade channels for clothing for restaurants and motorsports do not overlap, right? Because restaurants oftentimes promote their restaurants with clothing that you can wear to promote the restaurant services, and has nothing to do with motorsports. They could be the same classes of purchasers, but there is no evidence to support a finding that applicant's mark and registrant's mark will be encountered by the same consumers under circumstances likely to give rise to the mistaken belief that they're associated. So even though the Works and Works are very similar visually, the goods here in particular are sufficiently distinct because of the addition of, for the applicant, that is related to restaurant services and food products. But in addition to that, the TTAB also found that the meaning of the marks are different as applied to the goods in the registration in the application. So in the restaurant context, the Works means everything on it, right? So a sandwich with the Works, pizza with the Works, it's all the toppings, all the whatever you want to put on it. It's, giant mess piece of food. So that has like a meaning in the restaurant world. Whereas Works in the motorsports field has sort of this engineering structure feel. So that makes the terms, even though the words are essentially identical, have different connotation as applied to the goods and services. So that's why I was talking earlier about, are there ways in which you can revise your client's description of goods and services to add a trade channel, to add in a field of that distinguishes it from the cited registration, to help with the argument, even if you're just preserving it for an ex parte appeal. Okay, so this is another 2013 TTAB non-presidential case, and this is for Bentley, filed by the famous car maker, and they wanted to register perfume, cologne, aftershave, deodorant, cosmetics, etc., and articles of glass, so 2 classes, 3 and 21. And in the registration was cited, there were 3 registrations, 2 in class 21 and 1 in class 3 and 5. All right, but in this particular case, Bentley Motors argued that they would only sell the perfume and articles of glass in authorized vehicle dealers. So even though Bentley itself, the marks are identical, and is not shown on the slide, but I'll tell you that the Bentley registrations as cited did not have any restricted channels of trade. But the board concluded that there was no evidence that the ordinary channels of trade for the cited registrations involved applicants' dealers. And that was sufficient to then overcome a refusal based purely on the difference in trade channels. So that is something to think about. And when you are, arguing overcoming refusal, add it into the amendment. How is sold? Where is sold? Especially if it's only going to be sold in a limited trade channel, that might help you overcome the refusal. All right, the last example, VTEC versus VTEC. So the applicant makes custom wheels for vehicles, and they call it V-Tech. And then Honda owns VTEC for vehicles, automobiles, and particularly the engine. And, you look at the marks like, wow, it sounds the same, it looks the same. How do they overcome this refusal? And the, examiner was actually very adamant. They said, look, this is related to vehicles and parts and accessories, and they're, Honda's website shows that they also sell wheels and they do replacement wheels, although not necessarily under the VTEC mark, which is a secondary mark for Honda. And but the TTAB, and the applicant in this case said, look, OEM and custom wheels are very different, and especially when VTEC is used for specifically engines, and the engines are not related to wheels. And also, VTEC stands for a common descriptive term in the automobile industry. And the other thing that the applicant argued was that the examiner did not provide enough evidence that, there is a per se rule that automobile makers are always OEMs of wheels and engines, because sometimes they are not, right? So they don't always necessarily sell those products themselves, and they license that and brings those in and put them on the cars themselves. So the board agreed with the applicant. They said, look, there's not enough evidence on the record that automobiles or vehicle engines from the original equipment manufacturer are sufficiently commercially related to custom aftermarket wheels. The confusion is likely. So while car manufacturers put their house mark on a variety of different parts and replacement parts, it doesn't show that they actually do it for that VTEC here is not necessarily, there was not enough evidence to show that VTEC here was a house mark. It was actually really just for engines. And there's enough of a difference in a vehicle automobile manufacturer and custom wheels for vehicles that there is enough of a difference between the goods and services, even though the marks are very similar. And then the board also added that the conditions of sale also minimizes potential for confusion, because the purchasers take a really long time and careful process in deciding, which car model, which manufacturer, and the type of wheels that they want to purchase, or the type of automobile and engines of sophistication of sophisticated customers on both ends. And as a result, there is no confusion. So even though you look at this and you get this, you go, oh my goodness, they're very, very similar. with the right arguments, you can overcome this refusal. Okay.
Awesome.
Yeah.
Go ahead.
Sorry, just one last, if all of this doesn't work, one of the other things you can do is get a consent agreement, but there are some potential downsides to that, right? If you go ask for consent or a letter of consent from someone else, they may not have known about you, but now they see it and they're like, oh, you need my consent. Maybe you are infringing on my mark. So that's, those are all the risks you have to think about. And another note that if you do get into a consent agreement, make sure you state the reasons in the agreement why confusion is not likely, and is signed by both parties, and then they will both take actions to avoid confusion, or the PTO may not accept that letter of consent.
Terrific, thank you. And that's another thing you can find in the record sometimes when you're looking at cited registrations. Sometimes when you look in TSDR at their file history, sometimes you see consent agreements, and they're great examples and can be part of the whole story for trying to find a narrative to fit your applicant's mark in. Thanks, Kelu. We're going to now run through descriptiveness as quickly as I can and save a few minutes for questions at the end. Here we see the Lanham Act quote from Section 2E1 about descriptiveness. The key is that no trademark shall be refused if it consists of a mark when used on or in connection with the goods and is merely descriptive, is what we're talking about today. And the word merely is important, of course. Now, here is an example of a common descriptiveness refusal under Section 2E1 that you will often receive from an examiner. This is the beginning part of it, at least. And you can see from these first few paragraphs, it's really all standard TMEP or template type language. But it is important to know those sections of the TMEP, as it is, I will say, with the other refusals as well, of course. And it can be really valuable to actually go and read some of these seminal cases that are cited all the time, because there's a reason that they're the seminal cases, and they tell you a lot about the context of this refusal, in our case, merely descriptive. So, for example, one that you'll see come up in my discussion later about a mark that was found not descriptive, sugar and spice. It's cited by applicants all the time. I wonder how many people have actually gone and read the case. Wonderful thing, all these materials, are so easy to find online through the USPTO and other places. But back to the refusal here, what I'm looking for when I get a descriptiveness refusal is to try to hone in on the few key sentences that are not template language, where the examiner is really doing an analysis of why they think the mark here is descriptive for the goods or services at issue, and really honing in on that and on any evidence that's cited by the examiner to start thinking about what the strategies might be for responding. But before we even talk about responding, here's more seminal language about descriptiveness refusal. And of course, it can be descriptive of just any ingredient, quality, characteristic, function, feature, purpose, or use of the goods and services. But other important language there is with a degree of particularity. Before I start thinking about building a response to argue against descriptiveness refusal, want to consider the other options, because sometimes you don't respond. Of course, client goals and consultation is an important part of this as well. But there really are four main options when you get a descriptiveness refusal. One is to argue in response. One is to claim acquired distinctiveness under Section 2F to try to overcome the descriptiveness. And sometimes you might do that or try to do that right away. Sometimes you might do that after submitting a substantive response if it fails as sort of a backup option. We'll come back to that in a moment. Amending to supplemental register, same thing. Sometimes you might do that right away. Sometimes you might wait after trying to respond. But probably overlooked is the option to let it go and do nothing. And I will say I was trying to think of instances where I haven't responded in one of these ways, but I think that there probably are some examples where you would say, we don't want to respond. We don't want to let the examiner build even more of a record, perhaps, that the mark is descriptive, if we think that ultimately we may not succeed in overcoming it, and perhaps we're not using it long enough to claim acquired distinctiveness. Or there could be some sort of reverse competitive logic where perhaps if the mark is used descriptively, or different variations of that mark really are used descriptively by lots of people in the marketplace, lots of competitors, maybe there is some value to the USPTO actually having found the mark descriptive for your client if they're worried about receiving an infringement action from a senior user of a similar mark or some related circumstance like that. And here's some more about that option of letting it go. Again, that benefit is that you might be making it harder for someone else to assert a claim against your client. So it's sort of a silver lining, I guess, if you get refused as descriptive and you decide not to do anything else. As far as the amendment to the supplemental register, that is an admission that the mark is weaker and descriptive. Now, that doesn't mean that you can't come back later and reapply and try to seek acquired distinctiveness based on either evidence of secondary meaning and acquired distinctiveness, or in many cases, more than 5 years of use. But remember that more than 5 years of use is not a guarantee that you're going to be granted acquired distinctiveness, especially if the mark is found to be on the spectrum, very, very descriptive. I think that there are different opinions about this, and I'd love to hear what your takes are on it in the chat. I think that some think they don't want to counsel the client to admit that the mark is weaker and accept the supplemental register, and they'd rather give up getting a registration. I personally think that most times, maybe even 9 times out of 10, it's probably better than nothing to have something on the register, even if it is on the supplemental register, because when you're in the register, the client's mark is in that database all the time. And people searching that database all the time don't necessarily know what the supplemental register is or even means. And of course, the client can still use the arm of the circle. Now, drawbacks are it's not going to help them with the Amazon brand registry that more and more clients care about. And of course, they're not going to get many of the presumptions and help in an enforcement action that they would get if it was on the principal register. So something to think about there, pros and cons of the supplemental register. Acquired distinctiveness, again, be careful that 5 years may not be enough. And that if you're trying to assert acquired distinctiveness based on substantial use in sales and marketing and media, the most important thing I've found here is you really have to counsel the client about what type of evidence and how much evidence is going to be needed. Of course, if you ask a client, is their mark well known? Do they think it's acquired distinctiveness? Most of our clients will tell them that they think will tell us that they think it has. But they need to understand the context of what type of evidence is and volume of evidence is likely to be accepted for that finding. Also, key considerations here in determining what the strategy is in these options dealing with the descriptiveness refusal is where the mark is or could be on that spectrum, because it's a spectrum. So there's not one descriptiveness. Within descriptiveness, there are shades. Is it on the descriptive suggestive border, or is it on the descriptive generic border, or is it somewhere else? And also want to consider now, if we're considering arguments, can we argue that it's not merely descriptive? And we're going to see a little bit more about that. Or is there a double entendre? or is it not immediately descriptive? And this one is really hard to verbalize and to wrap my hands around. So I imagine it's that way for others, but I have had some success showing that even if it is arguably descriptive, if it takes several steps to put together, okay, this is what the mark means, and this is the context, and this is how it would be applied to the goods or services, that just having to go through those certain steps and that it's not quickly intuitive, that's enough to perhaps convince them that it's not immediately descriptive. Here's some more case law on the determination of descriptiveness. I'm going to speed through that so we can get more to some sort of sample arguments. Key thing to remember with descriptiveness, like other refusals, the examiner has the burden. And that's why, like I mentioned on failure to function, it's important to look at the evidence. What evidence has the examiner provided and attached? And what evidence might there be to support the arguments that the mark is suggestive and not merely descriptive? Oftentimes, it's very useful to look at the treatment of other marks on the register that use the same or similar words, possibly for the same or similar goods or services. So if you can find that there already are a variety of marks that have been registered using the term and they're on the principal register, that might be good evidence to support your argument that it's not merely descriptive. Of course, it's always going to depend on the context of the goods or services at issue in the application. But that's a good place to start. And it can be useful to look at and see, were any of those other third parties initially refused as descriptive and overcame arguments? Maybe there's some insights or evidence there to look at that someone's already put together. So the test records from third parties I find to be tremendously helpful in this context, just like they are in so many other contexts. So on the flip side of that, if you see that the words in the mark you're dealing with here appear in other marks as well, and the vast majority of them are on the supplemental register or were refused as descriptive and never responded to, that's going to make it, that's probably a good indication that you're going to have a very uphill battle. And remember, when you're searching those third-party records, to take into consideration the ones that have 2F claims or are on the supplemental register, because those are going to be, not as valuable in your analysis.
Real quick, Erik,
Go for
I
it.
don't want to interrupt you, but I'm going to come in, I'm going to say the code, and then I'll give it back to you. Our CLE code, make sure to write this down, is the number 9, the word action, the number 4. Again, that is 9, action, 4. All right, sorry. Continue.
Thank you. So, common argument, double entendre. I've found that this argument may be successful in more descriptiveness cases than any other one. And I think the reason is that sometimes the examiners may not recognize the multiple meanings. Double entendre, of course, indicating that there are multiple meanings in the context of how the mark is used with the goods or services. So I mentioned the sugar and spice case. That's a big case. Be aware of it. There's an example here. You can take the serial number from the slides and actually look at the TSDR history from the examples of these cases that we're providing in the slides. Solar Grown was successful, was able to show that not only it involved farm products, and that not only were the farm products, of course, grown under the sun, but that the particular use by the client relates to solar energy and solar panels. And so solar had more than one meaning here and a double entendre. Another common argument is that the term is not merely descriptive or requires some imagination by the consumer to figure out the meaning in context of the goods and services. And so you see here example of Speedy Bake for frozen dough was found to fall in the suggestive marks because it only vaguely suggests a desirable characteristic of frozen dough, namely that it quickly and easily can be baked into bread. So again, suggestive, descriptive, like most things in trademark law, which makes it exciting for all of us, it's not black and white. There's so much gray area in between, and making these creative arguments to me is what makes it fun and exciting all the time. And I trust that it is for you as well, or you wouldn't be here. Here we've got more on that it requires imagination, or it's not merely descriptive. No burst for liquid antifreeze. And then 2 cases with serial numbers, accumulation wealth management, and K Chicken is a recent one that my office had. It was, the examiner found that it was descriptive for Korean style chicken restaurant services. And we were able to show that there were many K hyphen descriptive term marks that were registered without being held descriptive as a whole, where the K could reasonably have indicated Korean, or that it could have other meanings. And that was successful in overcoming the refusal. Common argument and thread through all of this is that it's the examining attorney's burden to show that the mark is merely descriptive. And if there's any doubt, it should be resolved in favor of the applicant. Another example here, small firm scorecard, where we introduced at least 20 third-party registered marks that did not have a disclaimer of scorecard, but were used in sort of similar circumstances, and those were all in the principal register, and that was successful in overcoming the descriptiveness refusal there. So I'm running out of time here, so I'm just going to close with some final thoughts before we get to a few of your great questions. Remember the range of options and the strategies, and of course, in a trademark application, sometimes thinking not only of the next step, but of a step or two ahead and playing a little game of chess and what might happen and all the different options. Evidence, evidence, evidence. The examiner's evidence and your evidence that you can put into the application. Those are overwhelmingly what's going to be persuasive in any descriptiveness refusal and response. So let's go back to some questions now. And Kelu, I'm going to start with a question for you, if you don't mind. You're on the hot seat here.
Okay.
We had a question from Brian, I believe. Do you approach a 2D differently if it is a prior filed pending application versus an existing registration?
The short answer is yes, because technically a citation to a prior filed pending application is not technically a Section 2D refusal, is a potential refusal. And I think if you look at the office action, there, it's like a warning or something where they is not actually a refusal. And even so, when I look at a cited prior pending application, I do sort of 2 things. So one is determine whether, the chances that we can overcome the refusal via argument or some of the other, tips and tricks we've taught right away with the application as is. And then if I feel like, I don't think, we want to restrict our clients' goods and services too much based on this prior pending application, then I may, if the client is okay with it, and I would recommend is suspend the application pending the outcome of the prior application, because oftentimes they don't proceed to registration or they're refused on something that will be difficult for them to overcome. And that way you are not restricting your client's registration based on something that may go abandoned. But the risk with that is it could take years for that application to resolve, especially if there are multiple prior pending applications. So that's sort of the analysis I would make when I receive a potential refusal based on a prior pending application.
And one thing I consider as well when on any 2D response, but particularly with whether or not to address a prior pending, is remembering that what you put in the record responding might be looked at somebody else in some other case down the line, or with a potential infringement situation or opposition situation, just like you were saying, Kelu, that you want to look at the third party, that at who was cited and what they argued. You might be on the flip side of that for somebody else in a future situation. We had a question about the Amazon brand registry and whether you need registration or just the application number. There is some confusion about that, and I think that currently you only need an application number, but I think that also if you end up on the supplemental register, it does not meet their guidelines. And also, to my knowledge, nobody's quite sure what happens if you join the registry with an application number, but then fail in the application, and whether Amazon is tracking that and you would lose the brand registry status or not. If anybody else, I don't know, Ruky or Kelu, if you've encountered that.
Not in that scenario you just posed, no.
Yeah. Ruky, we've got a question. We've got a few minutes left here. Question from our friend Anne Lalonde. Given that trademark validity is all about context, do you think that the USPTO would register Taco Tuesday for any goods or services, like a board game or something unlikely, like deodorant or financial services?
Thank you for that. So it really comes down to the argument. So one of the things that we've seen over and over and over again in the failure to function refusals is the USPTO citing to goods and services other than what the applicant actually applied for. So in the case of Dare to Be Different, that was for cookbooks and frozen vegetables. And the USPTO cited to t-shirts and phone covers and things that they saw on Etsy. So again, kind of going to the argument that in this particular context, for the actual the relevant consuming purchaser, the actual term isn't necessarily commonplace. But I did want to kind of go back to what's happened with another Taco Tuesday application that was applied for even prior to LeBron James' application. So, LeBron James got the failure to function refusal in about 2019. But there was another Taco Tuesday application that was applied for registration in 2017, a couple of years prior to that refusal. And, around the time of March 2020, they did get a notice of allowance. And as, is often the case with a lot of trademark applicants who have not yet launched their goods and services, they applied for an extension. And they applied for about 3 extensions. But between the 3rd and the 4th extension, the USPTO actually issued another office action, actually about a month ago, August 7, 2021, saying that, hey, we just found out that, we changed our mind. This mark fails to function as a trademark in total. So because your mark has not yet registered, we're actually going to deny registration unless you show us why this mark now functions as a trademark. So it speaks to a couple of things. And I think what the USPTO is trying to do is it's attempting to be consistent, primarily because this Taco Tuesday refusal to LeBron James's case got so much fanfare, right? And at the same time, they're also saying, we're trying to let you know before this registers that this mark should not be afforded the proper registration. But again, why does this mark, not get registration? But you got, and I think Christian Williams raised this, you have this Sig B and other similar, like very trendy marks getting registration for very similar goods and services. So I want to kind of bring us back to the original caveat, which was, the USPTO is very inconsistent with the administration of failure to function refusals and then the underlying analysis when such refusals are administered. But kind of going back to the common arguments that we've seen over and over that have overcome such refusals, kind of narrowing the niche down or citing to other registered marks, or saying this mark unequivocally points to the applicant, or saying the actual mark that you're saying is commonplace isn't actually as commonplace or isn't actually the market issue in this case. So hopefully that helps.
And I think we've got time for one more question. Let me just say before that, if we haven't gotten to your question, we apologize. You can email us or find us on social media or LinkedIn or wherever, and feel free to ask your general questions. Of course, can't provide specific advice, as Bree informed us at the beginning. One last question. Kelu, we have from Christian. Is it risky to commit to a trade channel to overcome in office action to potentially undercut your client who may expand their business in the future?
I see it this way, and I'll try to answer this really quickly, which is, if you don't restrict your trade channel, you may not be able to get a registration at all. And the registration does not limit your client's ability to use and maybe expand their business in the future. And as I think we've all touched upon through all of our presentation is, trademark and the validity and, how distinctive a trademark is changes over time. So what may be refused today may be available for registration tomorrow. What was available for registration 3 years ago may no longer be available for registration today. So I think that is something we have to keep in mind and make that best decision and recommendation for your client at that time.
I think that's a perfect place to wrap us today.
It absolutely is. Thank you so very much, Erik and Kelu and Ruky. This was wonderful, and I know our audience was super engaged with it. There were lots and lots of there's lots of discussion and lots of resources shared and all sorts of things. So we will try to share those with everybody. We currently now have about a 10-minute break before our final full session of the day, which is putting the buzz back in blogging. New tips for a mature medium, which is starting at 4:40 Eastern time. So take about 10 minutes or so. I will see you back here at 4:40. Thank you so much, panel, and thank you, audience, for joining us for this.